Hey everyone, Harry here to talk about Jack Smith's response to a whole flurry of pretrial motions by Donald Trump. All right, so just to situate this, we're in the period before trial where a defendant tries whatever they can to, throw stuff against the wall and hope that it sticks. It's typically going to be a very poor kind of wheat to chaff ratio. That's just the way it works, and the courts and lawyers understand that. They're trying out what they can and maybe hoping to get some ingenious issue or idiosyncratic one that they can use on appeal. So Trump has had a flurry of motions of all kinds of different theories to see what sticks to the wall. Basically nothing, as I'll explain, I think sticks to the wall. So on the one hand, that's par for the course for Trump, who has, offers rhetoric instead of law repeatedly and really doesn't have good legal defenses anyway, but it's also where we are in trial. So they've now been served up with the responses from Jack Smith to Judge Chutkan. I'll talk a little bit about what happens next at the end. Two things I want to sketch out about the responses. There's this omnibus response, 80 some pages to many different Trump claims. And then there's a couple individual ones as well, maybe giving, slightly more respect to those. But the headline here, I think, is rhetorical. So it's pretty remarkable or noteworthy, the kind of scathing criticism of a former president of the United States that just comes off the page. The gloves really are off here, and they've made a calculation that with a different defendant and a different former president, you might not make. You might think you always have to, Mr. Trump this, Mr. Trump that, and act very respectfully. You're the United States after all. They trash him, and they have no hesitation. So just a couple kind of money quotes from the introduction and that are peppered in to the long legal rebuttals to Trump's claims. The defendant stands alone in American history for his alleged crimes. No other president has engaged in conspiracy and obstruction to overturn valid election results and illegitimately retain power. Imagine if that were, say, in a history book, and that was the account of Donald Trump. That makes him a villain unlike any other maybe in our political history. And then what about his arguments? Do they give them kind of, respectfully? The defendant exaggerates when he claims, The defendant attempts to rewrite the indictment, claiming that it charges him with wholly innocuous, perhaps even admirable conduct. I really like that line because Trump has this habit. We saw him when he testified. He doesn't simply say it's what you could call the perfect call defense. It's never that, no, actually, that's not well taken. Whatever is charged against him, he turns around completely and says, actually, everything was perfect, and I couldn't have done better, and I couldn't be richer, and I couldn't be more awesome, and the magnitude of me, Donald Trump. So perhaps even admirable conduct, and it's true that some of his motions actually make it seem like he was some kind of, patriot protecting the people's First Amendment rights. Sharing his opinions, perhaps even admirable conduct, sharing his opinions about election fraud and seeking election integrity. That really is a flavor of what Trump has to say, when in fact it clearly describes the defendant's fraudulent use of knowingly false statements as weapons in furtherance of his criminal plans. This is a common criminal that they're not pausing to be decorous on account of his former office. And, actually, on the contrary, that he occupied this former office is part of the rhetorical attack on him. If the defendant is correct in his claim that the indictment is unprecedented, it is only because the defendant's conduct is unprecedented. So this is really not, you might have thought it could have been greater degree of politesse or deference to Trump and his office. And Jack Smith has no trouble really, calling him out for what he is. All right. So I wanted to give that flavor, and that's in front of Chutkan as well. And it maybe gives her some steel in the spine to say, yeah, that's right. That, former president trying to help election act integrity. No, that he's a common criminal and a vicious one given the gravity of the crimes. Okay, then there's like half a dozen, literally, motions that Trump makes, and we don't have to go through them in great detail, but I just want to summarize them for you briefly. Because that the next sort of big thing that's going to happen is Chutkan will respond, and you'll be getting stories about this or that pretrial motion by Trump. Very likely rejections, denials of the motion. That's point one. And then point two, this might live on for a while. In the best case scenario, as I've emphasized on several occasions, this is going to be on appeal in November 2024. And almost certainly he will not be in jail. And so the fight will potentially be at the Court of Appeals about different legal issues. And that will include his appeal of these denial of pretrial motions. Okay, so let me just sort of blitz through them anyway. There's the omnibus motion starts by saying Trump takes the statute he's charged under, the 18 U.S.C. 371 for obstruction, and says that the United States indictment doesn't even state a claim under that statute because all it says is he engaged in advocacy. That's ridiculous, I think, would be the fair answer. And if you didn't have sort of the sophistication of a criminal practitioner, you might say, what the hell is he even trying? But again, this is what happens at this stage of trial. Here's something else, for example. This is just a preview, but no matter what happens in a criminal trial, no matter how strong the defense is, at the end of it, the defendant will stand up and make a motion that it now must be dismissed because the evidence no reasonable juror could conclude that's rejected as a matter of course, but it's just, you make every effort as a defendant. That's just part of the sort of dance here. Okay, so makes really quick work of the notion that we didn't even state a claim under the statutes. Yes, of course we did, and here's exactly why. All right, and then they move to a series of constitutional motions that Trump has brought. The first is, this is all protected speech. It's the First Amendment claim. He's been saying, he continues to say it really on the hustings. They're just punishing me for speech. This again, they make quick work of just, and we've been over this before in the last several weeks. Most, but not all of the crime he's charged with come from words that emerge from his mouth, but they are criminal words, or they amount to a conspiracy to obstruct justice. And, there's no free speech defense. It's just a sort of disconnect. He says that there's a due process violation because he didn't get really fair notice of the claims from the indictment. That one is, here's the argument. No one has ever been charged with this scheme before, so I can't really say what there is to defend against. And that is the context for Smith's pithy response. Yeah, no one's ever been charged with it because no one's ever done it before. And of course he has notice. All you have to do is read it, and he knows what he has to defend against. He argues double jeopardy. Check this out, because he was already charged and acquitted when in the Senate impeachment trial. a total non-starter. There's an opinion on this, in fact, by another district court judge saying that doesn't fly. And, he's had no criminal process, no criminal penalty, no threat of criminal penalty. Impeachment just is about expelling you. So he hasn't, been twice put in jeopardy of life or limb, as the Constitution says. So there's, no possible double jeopardy claim. Selective prosecution, basically they picked him out among all others. And again, we have, selective prosecution is about really, and it's a very hard claim to make in any event, but it's one man's selective prosecution is another's prosecutorial discretion. But he's saying no one's ever been charged with this crime, and again, there's no similarly situated defendant here. There's only Trump in American history. Next, vindictive prosecution. It sounds similar, but it's a little bit different. What it means is that the defendant has been indicted in a vengeful way by prosecutors as a reprisal for exercise of his or her constitutional rights. Here's one where Smith actually takes a little time and pushes back and wraps himself in the DOJ flag. He actually goes through who the people are in his office and their experience at the DOJ and how fanciful it would be that they're going after Trump because of exercise of his constitutional rights. By the way, what constitutional rights? Presumably, I guess it harkens back to the First Amendment claim and advocacy. But see, that's an already solved problem because it's not a First Amendment issue. There's a couple other pretrial motions having to do with, and these are skirmishes that occur all the time, about specific responses to discovery requests and subpoenas. And Chutkan actually gave Trump a little bit of a break here, gave a small extension to that. So gave him more time to make those claims, and so hasn't decided them, but not in a way that interferes with the March 4th trial date. We have a March 4th trial date here. That's pretty soon, and a February 9th date for beginning sort of jury selection procedures, haggling about a jury questionnaire. That's coming. Okay, and then finally, so where does that leave us? Smith also this week came in and said, District Court, you have all these things, you can decide them now, but two of them, the law provides the possibility for Trump to appeal immediately. Most pretrial motions, you have to wait until a trial is over. Of course, if you're acquitted, they go away because you can't be retried. But if you're convicted, then you can make your First Amendment claim again, your vindictive prosecution claim again. But, good luck with it. However, both double jeopardy and immunity are rights that essentially entitle you not to face process at all. So the violation there, if there is a violation, is standing trial in the first place. And for that reason, the law provides for what's called an interlocutory appeal. That is, assuming she decides against him on immunity and on double jeopardy, he can bring an appeal to the Court of Appeals, potentially even the Supreme Court. So Jack Smith has said, please, Judge Chutkan, do that first so we can try to quickly get up to the Court of Appeals and so we're not delayed. That's all well and good for the double jeopardy claim. She's gonna make very quick work of it, and the Court of Appeals will also, not break a sweat or take any time to affirm there. So for all the pretrial motions, here is point 3. Point 1 is their rhetorical gloves are off and treat him with the respect he deserves as a common defendant who tried to steal the election. Point 2, I've taken you just very briefly through the different motions, so you're not around it. But point 3, the main event here remains the immunity motion, which he wrote somewhat seriously, very serious response from Jack Smith and a right to interlocutory appeal. So she's going to decide that. and there's going to be a right. And that, I've said from the day it dropped, is the one that might be a vehicle for serious, like, treatment by the Court of Appeals, long oral arguments, not immediate dispatch, possibly even Supreme Court review. So that's the big chunky motion to keep your eye on. Everything else is just, fodder to that Chutkan should have no trouble with, and that should, in the event he's convicted and he presses it down the line, also have no real purchase for him. So, as before, keep our eyes on the immunity motion, and then just, note the time is coming, and it's, 3 months until we're in earnest in litigation here. And those weeks will tick off pretty quickly, especially since in between now and then we have the fraud trial that's going on now, the E. Jean Carroll defamation case scheduled for January, and you don't know, but we'll see when Judge McAfee sets trial for in Fulton County. So, not much breathing space for Trump. And I think no real headway on any of these motions, with the possible exception to keep our eye on of immunity. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.